If you have applied for Social Security benefits and been denied, or if you are afraid to apply because you fear rejection, subscribe right now. The Social Security system denies the majority of first-time disability applications. Most people who are denied give up. They should not. This video exposes the real reasons claims are blocked, not the official language on the denial letter, but the actual mechanisms that are stopping real people from receiving benefits they legally earned, and what can be done about each one. Here is a scene that happens thousands of times every week across the United States. A person, sometimes young, sometimes old, sometimes in obvious physical distress, sits down and fills out a Social Security application. They describe their condition honestly, they submit their medical records, they answer every question, they wait months, and then a letter arrives. Denied. The letter gives a reason, but the reason in the letter is rarely the full story. It is the official explanation, the administrative language required by the process. The real reason, the actual mechanism that caused the denial, is usually something different, something the applicant did not know to watch for, something that could have been avoided, something that, in many cases, can still be addressed through an appeal. This video is about those real reasons. The first real reason claims are blocked is one that surprises nearly everyone who hears it for the first time. Social Security disability benefits, specifically SSDI, are an insurance program. They work like insurance. You pay in through your working years via the payroll taxes taken from every paycheck. In exchange, you earn what are called work credits, a specific number of credits based on your annual earnings. To qualify for SSDI, you need a minimum number of credits, and crucially, you need a minimum number of recent credits, meaning credits earned in the years immediately before your disability began. For most people, this means having worked at least 5 of the 10 years immediately preceding the disability. If you stopped working for an extended period to raise children, to care for a parent, to deal with a prior health issue, or simply because of economic circumstances, and then became disabled years later, you may have let your SSDI eligibility lapse without ever knowing such a thing was possible. The credits are there in your record, the payments were made, but the recent work requirement was not satisfied, and the claim is denied on technical grounds that have nothing to do with how serious your medical condition is. Consider someone like Deborah, a 56-year-old woman from Atlanta, Georgia, who spent 8 years as her mother's primary caregiver after her mother was diagnosed with dementia. During those 8 years, Deborah did not work. She had worked consistently before that. 20 years of payroll taxes paid into the system. But by the time her mother passed and Deborah tried to return to the workforce, her own health had declined significantly from the physical and emotional demands of caregiving. She applied for SSDI. The denial came back within weeks, not because her condition was not serious, it was, but because the 5 of the last 10 years requirement was not met. 8 years of caregiving had pushed her paid employment outside the recent work window. Deborah had never heard of the recent work requirement. She had assumed that 20 years of contributions guaranteed access to disability benefits if she ever needed them. Nobody had ever told her that stopping work could silently erase that eligibility. The second real reason claims are blocked involves the income threshold, and this one catches working people completely off guard. To qualify for SSDI, your disability must be severe enough to prevent you from engaging in what SSA calls substantial gainful activity. The agency defines substantial gainful activity as earning above a specific monthly threshold. In 2026, that threshold is $1,690 per month for non-blind individuals. If you earn above that amount, even from part-time work, even from work that is far below what you did before your disability, SSA considers you able to perform substantial gainful activity and denies your claim on that basis alone. The medical evidence is not reviewed. The severity of the condition is not evaluated. The earning above the line is sufficient grounds for denial. This creates an impossible situation for many people who are genuinely disabled, but who have been pushing through pain or limitation to work part-time because they cannot afford to stop. They are working too much to qualify for disability. They are too sick to work enough to support themselves, and the system, as currently designed, offers them no middle ground at the initial application stage. Consider someone like Raymond, a 61-year-old former construction foreman from Phoenix, Arizona, whose degenerative spine condition forced him to leave full-time construction work 3 years ago. Raymond has been doing light administrative work for a contractor friend. Twankchiji may as the say pre-tree trelly smaller section tar pre-tree after earning just enough to cover his most basic expenses. When Raymond applied for SSDI, he assumed his decades of construction work and his documented medical condition would be the determining factors. The denial letter cited his current monthly earnings, which exceeded the substantial gainful activity threshold. The medical review never happened. The application was closed at the technical eligibility stage. Raymond did not know that continuing to work at any level above the threshold would end his claim before it began. His attorney, whom he contacted after the denial, told him the same thing many disability lawyers tell clients in Raymond's situation. If you are applying for SSDI, your current income cannot exceed the threshold. There is no partial credit for working while impaired. The third real reason claims are blocked is the one that affects more first-time applicants than any other, and it is the one that the system itself has the most control over. According to confirmed data from the Social Security Administration, the initial denial rate for SSDI applications is above 65%. That means the majority of people who apply are denied the first time. But here is what that statistic does not tell you. A significant portion of those denied applicants eventually receive benefits through the appeals process. The appeals process has multiple stages. The first is a reconsideration, essentially a second review of the same application by a different examiner. The second is a hearing before an administrative law judge, where the applicant can present evidence, bring witnesses, and have legal representation advocate for them in person. The approval rate at the ALJ hearing stage is dramatically higher than at the initial application stage. People who give up after the first denial, and most people do give up, are walking away from a process that was not finished. The first denial is not a final answer. It is the beginning of a process that the system itself has designed to require persistence. The fourth real reason is medical documentation, or more precisely, the gap between what someone knows about their own condition and what the medical record actually shows. SSA disability decisions are evidence-based. The examiner reviewing your file does not see you. They see your records. If your treating physician has documented your condition conservatively, using cautious clinical language, recording good days rather than bad ones, failing to document the full functional impact of your impairment on your daily life, the file may not reflect the severity of what you actually experience. Patients often do not know that clinical medical records, which are written for other physicians and for legal protection purposes, may understate how their condition affects their ability to work. A doctor who writes that a patient has managed their pain with medication may be writing accurately, while the patient may be managing pain that would be described as severe and functionally limiting if the full picture were captured. Building a compelling SSDI case often requires working with treating physicians to ensure the records reflect not just the diagnosis and treatment, but the functional limitations that result. Consider someone like Helen, a 53-year-old former retail manager from Louisville, Kentucky, whose chronic pain condition had been documented in her medical records for 4 years before she applied for SSDI. Helen had been a stoic patient. She rarely complained about her worst days. She showed up to appointments on her better days, and her physician's notes reflected appointments where she described managing adequately with medication. Her SSDI application was denied on the grounds that the medical evidence did not establish a condition severe enough to prevent all substantial gainful activity. Helen's actual experience, the days she could not get out of bed, the nights she could not sleep, the weeks she called in sick repeatedly before finally stopping work entirely, was not in the records. Her attorney helped her work with her physician to document a more complete picture of her functional limitations. Her appeal was approved. The fifth real reason is what disability attorneys call the 5-step sequential evaluation, and specifically failing at step 5. After SSA determines that you cannot perform your past work due to your disability, they ask one more question. Can you perform any other work that exists in significant numbers in the national economy? Any work. Not necessarily work you have done before, not work in your area. Any work anywhere that someone with your age, education, work history, and functional limitations could theoretically perform. If SSA determines that such work exists, even if you have never done it, even if there are no such jobs available near you, your claim can be denied at step 5. For younger applicants with transferable skills, this step is particularly difficult. SSA's vocational analysis may identify jobs that technically fit the residual functional capacity profile without any practical connection to what the applicant can realistically do. An experienced disability attorney who understands how to challenge vocational expert testimony at an ALJ hearing can make a significant difference in outcomes at this stage. The most important thing anyone who has been denied Social Security benefits or who is considering applying needs to understand is this. The first denial is not a verdict. It is an opening position. The appeals process is real, it is available, and it works. Legal representation at the ALJ hearing stage significantly improves outcomes, according to every study that has measured it. Most disability attorneys work on contingency, meaning they charge no fee unless the case is won, and their fee is capped by federal regulation at a percentage of back benefits recovered. There is no cost to consult with a disability attorney. The consultation is free, and the difference between navigating the SSDI appeals process alone and navigating it with experienced representation is, in many cases, the difference between receiving years of back benefits and receiving nothing. Here is the confirmed summary. Social Security disability claims are denied for 5 primary real reasons. Beyond the language in the denial letter. The recent work requirement catches people who stopped working for caregiving or other reasons, and whose SSDI eligibility lapsed without their knowledge. The substantial gainful activity income threshold blocks people who are genuinely impaired but still working above the monthly limit. The system's own design relies on persistence through a multi-stage appeals process that most denied applicants abandon before completion. Medical documentation gaps leave examiners with records that understate functional limitations. And step 5 of the sequential evaluation allows denials based on theoretical work capacity, even when realistic employment is unavailable. Every one of these reasons has a response. Every one of them can be addressed through the appeals process, through better documentation, through legal representation, or through understanding the rules in advance. Leave a comment below with your state and your situation. Every comment is read. Subscribe so you do not miss the next confirmed update, because the Social Security system is built to process the straightforward applications and complicate the rest. And knowing how it actually works is the only way to navigate it successfully.